The title of this presentation, if I had to give it a title, is Estate Planning. Take care of yourself and your loved ones. And it's the reason I put yourself first. This is because this is how it should be. Most of us have spent many years taking care of people as spouses, as parents, as children, taking care of our parents. And we take care of everybody else except taking care of ourselves first. And the big part of estate planning is taking care of yourself first. Once you take care of yourself, you'll be in a better position to help your loved ones. So I said we're going to have some questions. So the first question is, what does estate planning mean to you? Anybody? Show of hands. What does estate planning mean to you? I know someone, when you came here, is the reason you came to this presentation. What did you have in mind when you thought you were coming to a presentation about estate planning? Anybody? Room of college-educated African-American women. I know we got opinions. Sora?
As a single woman without children, it means what will happen to my belongings as well as financial input for nieces, nephews, parents. What will happen after I'm no longer here?
That's a good answer. That's a good answer for anybody, whether you have children or not. Anybody else, what does estate planning mean to you? That's actually an excellent response. And it's personal. So, I mean, that's why I'm trying to figure out what are you all expecting to hear about.
Also making the preparations for tax distribution and those sorts of things so that you're not leaving the government more of your estate than you are your family.
That's absolutely correct. That's another piece of it. One thing I'm glad I didn't hear you all say, and I didn't expect to hear my soror say that, is a lot of people, when I go out and do estate planning, and when I made the transition from corporate law to estate planning, people said, why are you doing that? That's for rich folks. Estate planning is not for rich folks. It's not just for rich folks. And also, people always think that estate planning is just about what you leave to someone. Because I've had people tell me, oh, I'm not leaving my folks anything. I had to work for my stuff. They need to work for their stuff. Especially people who may be on bad terms with their children. They tell me that all the time. It's not just about that. It's about taking care of your loved ones, but it's also a great deal about taking care of yourself. That's what estate planning is about. Most people think estate planning is about what happens to your property when you pass away, but it also addresses what happens to you if you become disabled. And that is a part that when I go out and do educational seminars, I don't start with death. Because that's not something, number one, that's not something we like to talk about. And that's why we avoid estate planning anyway, because we still have these superstitions and fear of death, and if we talk about it, if we do something, we're going to die next week. That's not going to happen. By addressing these issues now, disability issues, and it's like now, you'll be able to provide yourself with some peace of mind and some security, that if something happens to you, you'll still be able to be taken care of. One thing, when I started to go into the estate planning arena almost 3 years ago now, is that estate planning is really a very important women's issue. I actually presented to the Cook County Commissioners, the Women's Commission downtown, and it's because it is a women's issue. Women tend to live longer. Women are 3 times as likely to be widowed, so we'll still be around with the stuff to distribute it. Women are likely to be the final decision makers regarding to what's left to families and charities. Even if you have a husband, the husband usually say, you take care of that. And so, and women really need to control their own fate. You don't really need to leave that to a husband or a court or your children or anybody else. You should decide that while you can. There are 3 basic keys to successful estate planning. The first one is to maintain control and dignity during your incapacity. Most of us spend a lot of time, all of you all probably took some time this morning to decide what you were going to wear today. You wanted to make sure that you presented a certain way when you came out of the house. You want to still make sure that you are presented a certain way even if you're incapacitated. You want to make sure that you still have a certain lifestyle. You want to make sure that you're still taken care of in a certain manner. And by doing some estate planning, you can make sure that happens. Another thing is you want to, if you have a successful estate plan, have quick and cost-effective wealth transfer at death. If you are leaving something to someone, you don't want them waiting 3 years to get it. You don't want them waiting 6 months to get it. You want them to get what you're leaving them as quickly as possible. And the third thing, which really is important for the women that I work with on estate planning, is protecting your beneficiaries from themselves and from others. Because some people, we know that we protect them now, financially, and we need to make sure that we're still able to do that if we can. Some more questions, because I've been talking too long now. How many of you, by a show of hands, know someone who's experienced enough memory loss that they couldn't take care of their own affairs? Most of us. How many of you know someone who has significant physical limitations that require them to get assistance with their care? That's disability. That's what we're talking about. Have you thought about who would do this for you if you needed it done? Sora stood up and said she didn't have any children. Most of the time when I do presentations, if people have children, they say my children will do it. Well, good luck with that. Sometimes they might, sometimes they might not. So you need to make plans for that. You just can't assume that they will. The flip side is I have some people tell me, well, my parents will do it. Well, if you're 70, even if you're blessed to still have your parents around and they're 92, I don't know about how much taking care of you they're really going to be doing. So we need to be realistic when we're talking about who will take care of these things. Disability is a major issue in our country now. Now you need to spend just as much time planning for disability as you plan for your own death. As they make improvements in health care, many people are living longer with illnesses that used to kill them. Now, I talk to people, I have a lot of friends who are doctors that the medical school and law school used to be across the street from each other. They still are at Emory. And I tell them, I say, y'all don't cure nothing. Y'all just keep us alive long enough, but we don't get cured. We're just constantly on medication. But it really is true that people, things that used to just take people out, now they're living with those. A study in 2010 said that 10%, 1 in 10 people in the world's population is disabled right now. So if you think about that, about how many of us are in the room, 40 of us, about 4 people out of this room will be disabled and need some assistance. When you think about disability, when you think about estate planning, you have to have a plan for when you pass away, but you also have to have a plan for when you if you become disabled. One of the problems that results from a failure to estate plan is a failure to maintain control over your health care decisions. That is one of the biggest issues. Who is going to speak for you medically if you can't speak for yourself? And a lot of these things I really want you to take away from this workshop. If you haven't thought about these things yet, think about it. These are big issues. When I'm doing people's estate planning, coming up with the money's not the big deal. Doing the other things are not the big deal. The big deal is, wow, I hadn't thought about who was going to do that for me. Or if they do come in and have a person, then I ask them a series of questions, and they soon find out that the people they thought would do that are not really the people who are capable of doing those sorts of things. So think about who will make your decisions. Will there be a family conflict? There are so many times, one of the things, groups of people who really need to take care of estate planning are blended families. You have your husband, or some husbands, their wives have passed away, they still have children from the first wife, they have a new wife. Now, the new wife is expecting that she is going to be the person to make these decisions, and so are the children. And the husband didn't leave anything in writing, and so now we have this family conflict going on about who is really going to make the decision. What type of care do you desire? Or what would you not want to do? There are some things that you just don't want to happen to you. And if you don't have the discussion with people, and if you don't put things in writing, how are they going to know? So that's very important. There's some cases in the news that really illustrate this, and I know that the group we have, some of these names will be familiar to you. How many of you all remember hearing about the Nancy Cruzan case? It was a case some years ago that this woman was in a persistent vegetative state. In 1983, she was in a car accident, and she was unconscious and didn't have any higher brain functioning. And she was kept alive with a feeding tube and medical care. And the family had a huge legal battle that went on. I told you she had the accident in 1993. The battle went on until 1990 in the courts about what to do with Nancy Cruzan. Finally, it was approved that they could stop feeding her, and in December of 1990, she finally passed away. But I don't think any of us want our family to be in court for 7 years fighting with the government or the hospitals about what to do if something happens to us, and that's the reality. How many of you all remember the Terri Schiavo case? That's a more recent case. And that is where Terri Schiavo's husband wanted to discontinue life support, but her parents did not. And so that was also a huge fight, and that battle went on from 1998 to 2005. And it was finally decided that her husband could terminate her life support. So these are things that you need to think about. A solution to all of this is take care of your healthcare directives. Make sure that you've done those. Identify decision makers. It doesn't have to be your husband just because you're married. That doesn't have to be your children if you have children. It could be a best friend that knows you really well. It could be a cousin, it could be a co-worker, but you identify who you want to make that decision so it's clear who you want to make the decision and so they don't have to fight. Give unambiguous healthcare wishes. If you don't want to be hooked up to machines, if you don't want to be an amputee, if you don't want blood transfusions, if there's any kind of thing that you do not want, make sure that you are clear with the people who are making healthcare decisions for you. Let them know and that you also get it in writing. Give critical guidance to your loved ones. Let your people know. When I first started doing estate planning, I worked on a newsletter that we published called Having the Talk. And it was about having the talk at holiday time because people don't like to talk about this kind of thing. But as you're gathered for the holidays, you know, it may seem kind of morbid, but it's the perfect time to talk to your family about your wishes. A lot of times people just don't have the discussion. And if you don't have the discussion, how are the people in your life going to know? Essential healthcare documents that everyone should have. First, a healthcare power of attorney. Everyone in this room should have a healthcare power of attorney. And that document sets up an agent who can speak for you medically if you can't speak for yourself. It's the first document everyone should have in their arsenal. Before I talk about who's going to get your car, and who's going to get your dog, and who's going to get your $50 you got left after you paid for all the things we need to pay for, and you have it in your bank account, I talk about who's going to speak for you if the doctor has to know what they're supposed to do with you. A living will. That's the next thing you should have. If you want to provide instructions for your family and the doctor regarding life-sustaining medical equipment, if you want or not want to have it, you need to let people know. Another document, several years ago, every time we went to the doctor, they made us sign this HIPAA release. That's all they talked about every time we came to the doctor, HIPAA release, HIPAA release. That is an authorization to protect your healthcare information. If you want your children, if you want your significant other, husband, girlfriend, if you want them to have access to your medical information, you need to have a HIPAA release. This is what I hear all the time. Most of my people who do estate planning are seniors, and their children come in and say, oh, I don't need a HIPAA release. Dr. Jones knows me. I go to the doctor with my mama all the time. He tells me all my mama's business. That is because your mother is sitting there with you, and he assumes that she has consent. But you will be surprised what happens with Dr. Jones. He will take a different turn when your mother can no longer speak. And then at that time, you may be surprised when Dr. Jones says, do you have a HIPAA release? That's a bad time to find out that you needed one. So make sure that you take care of that. A lot of what I'm saying to you too, a lot of us are in the sandwich generation, where we have children that we're responsible for and we're thinking about. We're thinking about ourselves, and we're also thinking what's going to happen with mom and dad. Because now we got to take care of their stuff too, and now we need to be concerned about what's going to happen with them. So it's very important that this comes across all three generations. Another common problem, another form that you need is organ donation. If you're an organ donor, let your people know. Put it on your driver's license, let your doctor know, let people know if that's what you want to do. Because I always give a big push for organ donation because it is commonly known that people of the same ethnic background usually make better matches with each other. And so if we want to help people in the African American community, I have tons of friends that need kidneys right now. So if you are somebody who's interested in organ donation, make sure you let that be known to your people. Any questions about disability and about medical issues?
Regarding organ donation, is it possible, let's say I'm an organ donor, but my mother, who will be my next of kin, living will and medical power of attorney, she says no. Who in that case would my wishes be honored, or will it go with whatever she
And that's an excellent question, and that's why one of the things I'm going to talk about, and we'll talk about it now, is the dangers of do-it-yourself documents and the dangers of these self-help, LegalZoom, those kind of things. I'm not campaigning for everybody to be my client because I couldn't help all of you all if I wanted to. But you need to get legal counsel because when you download those documents, those are often things that are missed. If I talk to my clients, I put a paragraph in there that says whether or not your agent can override your wishes. So that is an excellent question, and that's what I say. I say, now if mama doesn't want you to do this, is it okay if she changes things? And most of the time, people do say no. That's why I put it in there, because I don't want it changed. So that is something you should address. Yes.
So what's the difference between a healthcare power of attorney and a living will?
A living will only deals with life-sustaining things. That's kind of, I hate to call it this, but it's the do not resuscitate, or the pull the plug document. That's what a living will is. And a lot of people get confused when they call me and they say they want to do a estate plan. They say, well, I have a living will. I said, a living will does not have anything to do with property. A will has something to do with property. A living will only has something to do with life-sustaining medical attention.
Question.
Mm-hmm.
Now, that's the living will. What is the healthcare power of attorney?
The living will is just about the equipment. The healthcare power of attorney is who can speak for you medically, if you can't speak for yourself. That sets up an agent for you. Another common problem that we encounter by the failure to create an estate plan is there's no control financially over your property matters if you become incapacitated. Okay, suppose you have a short-term disability, you have a stroke, but you still have a mortgage on your house, and you still have a car note that still needs to be paid, and you still have all these things that need to be taken care of, but you have not left anyone in any sort of financial position to take care of these things for you. And again, I like to bring a little humor to this because it is a little serious. And I say, okay, you hate to have a stroke and not take care of anything, and then you come out of it and you get better and you have a heart attack when you find out they didn't pay your mortgage, they didn't pay your car note, you're about to get set out. You know, you don't want those kinds of things to happen. So you need to have people in place who can take care of things and keep them afloat for you financially, because you can't always assume that every disability is going to lead to death. And it's even more important if you have a short-term disability to keep someone keeping all of your affairs afloat.
You know, one thing, because years ago I used to do financial planning, but one of the things that I found in the African American community, we don't want to talk about death. We don't want to talk about illness. The one thing I had an older Jewish lady who was my mentor. And one of the things that she would say when she went to her client base is that one thing for sure, you're going to die. I mean, it was like the automatic thing, but we don't think like that, and we have to realize that it's a natural part of life. It's going to happen. You're not going to dodge it.
Right.
I don't care how good you are, I don't care how many vitamins you take, you aren't going to dodge it. But it's a cultural thing that we have to accept.
I wish I could take you and make you a plant in the audience whenever I go do a presentation, because usually I start off with, many of us have been to baby showers, and we play that baby shower game where you get safety pins, and if you say baby or infant or toddler or anything like that, they take your pin. I start off and say, if you never say death, if you never say dying, if you never say deceased, passed away, called to glory, whatever you want to call it, it's going to happen. It's not an if, it's a when. So since it is a when, we need to prepare for it, because it's going to happen. So we really do need to break down some of the stigmas that we have associated with death and just deal with it, because it is going to be a reality. And if we don't deal with it, here's the thing, it's going to have to be dealt with. So if you don't deal with it, guess who's going to have to deal with it? The loved ones that you leave behind. And some of them may be ill-equipped to do so. So we need to address it while we can.
Can I have a question? In handling financial matters for you when you're disabled, short-term or whatever, is that like, you know, if I am single, if I have another friend on my checking account, would that person be able to pay for it or not?
Look, oh Jesus, look, they're gonna make me pass that. I'm just joking with you. No, that's the point we're getting to, and you're actually making a good transition for me. One of the things that people do, seniors do it a lot with their children. They put people's names on their accounts. If you can take one thing away from this, do not do that, because you inherit their creditors. This is a real case with real people that I had. It's not like you have to run out to Daysor and like, oh, let me get this girl's name off my account.
You know, I'm on her account.
Well, as long as you don't do anything to her, then you're okay. But what happens is, here's what happens. The law looks at if you put someone's name on your account now, it's what's called joint tenancy. So they treat you both like you own it. So here's a real life case that I had, and I thought I was going to have to quickly turn to a divorce attorney, but I really didn't want to do that. One of my clients came in and she said, I tried to go to the bank to use my bank account. She had a new husband, so a third husband. So that's why I told her, please don't make it be your fourth husband. I went to the bank, I put in a check, it said I had X amount of dollars available, or in the account. Then it said I had like $5,000 less available. So she was trying to find out what happened to the account. They put the daughter, her stepdaughter, her husband's daughter, on the account, and she had an IRS lien. The IRS went and searched her social security number, found anything her name was on. They don't care if it's mom and dad's account, and they just put your name on it in case they're out of town or they need some help. Slap the lien on the account. Well, we had to go through proving that she never deposited any money into the account. We worked with the IRS and we said, look, this account is only for their pension, it's only for their social security. They only put her name on it just in case. If she would have made one deposit into that account, they would have kept the lien on. But we pulled the documents up, we showed she never made any deposits. They released her name and then they said, take her name off that account immediately. If you put people's names on your homes and they have debts and people put liens on them, they can put a lien on your home if you've added someone else's name to your deed. Now, if you just want them to get the money when you pass away, you do what's called a payable on death. And when you go to the bank, you make sure that that is what you say. You be clear with the people on the bank. I am not making them an owner of my bank account right now. I want them to be payable on death if something happens to me. Sorry, you had your hand up.
That was the question I was going to ask, because I know several people that passed, and they didn't have anything like payable upon death. They were unable to get their bank account.
That's correct. What the bank is supposed to do is the bank is supposed to freeze that account. They are supposed to report it, and then it's supposed to go through probate to determine who gets it if you haven't put anyone's name on it. Sora?
It's hard to hear the question, so whenever they say the question, would you repeat it?
Okay, I sure will. Yes, Sora.
I want to go back to the original question around the short-term disability. If someone is going to take care of paying my bills for me or whatever, how do I make that happen?
Okay, and that was the next point in the presentation, so we're going to put a pause and see if anybody has any other questions, because I'm going to tell you what's a better way to give people access to your finances if you become disabled and not right now. Because if you add someone to your account right now, they can get your account right now. And so you don't want to do that. Yes,
But
sir.
suppose you want the person to have access to, for instance, my brother is in a nursing home. So I have access to his account right now and I take care of all his bills.
If you're on an account now, that's fine, but understand, like I said, this is preventative, because right now everything is good. And if you're the person that's on the account, fine, but we need to always be cautious when we add other people to ownership to things that belong to us immediately. Let me get to this point so we don't forget it, and then I'll come right back to you. There's two ways you can do it. One, you can establish a trust. If you establish a trust, there is a part of a trust that can deal with death, and there's also a part of the trust that can deal with disability. So you can set it up and say, I want my trust, if I pass away, these are the people who I want to handle my affairs, and these are the people who I want to have my belongings. If I become disabled, I want to make Sheila my disability trustee. And then she is not an owner of my account. She cannot do whatever she wants to do with my account. She is supposed to take care of my affairs out of my account if she is my disability trustee. So that is one of the reasons now why trusts are recommended, because a trust can cover disability and it can cover death. And it does not give the person ownership over your account. They can only act as trustee for you. And actually, every time they access your account, they're accessing it. Julie Jones as trustee for Tracy Jones' estate.
But
Is what you're talking about a power of attorney?
That's not a power of attorney.
That's what I'm trying to ask you.
A power of attorney.
A power of attorney and what?
A power of attorney gives people access. It does say it gives them access after disability, and a power of attorney is the second method that you can do. A power of attorney delegates them, the financial institutions, to give them access, but what is happening now? If you are going to use a power of attorney, be very cautious, because do not just go download a power of attorney offline or get one that someone else used. You need to involve an attorney. Here is why. Financial institutions are having an enormous amount of fraud that is related to financial powers of attorney. I do a lot of elder abuse training, and one of the largest ways that elders are abused is a caretaker knows they bank at Chase because they get their mail, knows they bank at Citibank because they get their mail. They know their account numbers. Hey, I need you to sign my time slip for these hours that I did this week, and they're signing a financial power of attorney. That's a standard one, and they're taking it to the bank and say, here, Chase, I have Mrs. Jones' power of attorney. I need to make a withdrawal. So you need to be careful with powers of attorney. You need to be careful that you involve an attorney. Any power of attorney that I draft, I put specific language in there that says it can only be used if the person is disabled, if that's what they ask for. And sometimes I even put language in there saying that a doctor has to determine their disability. That they just don't have carte blanche to just roll up and chase with a power of attorney. They need to also have a certificate of disability from a doctor. But a power of attorney is another way to go. And that is actually a much better method than adding someone to your account right now. Yes, sir.
Can you designate a trustee if you are married?
You can make whoever you want be your trustee. Your spouse does not have to be your trustee. If you want your spouse to be your trustee, they can, but they don't have to be. It can be whoever you want it to be. Yes,
Is
sir.
a trustee the same thing as an executor of the estate?
No, an executor is when you pass away and they are appointed through a will, and they have to be approved by a court. But the two things that you can do if you're disabled, just to summarize, the two things you can do if you're disabled to give someone access to your finances is one, a power of attorney. It's called a financial power of attorney. So if you are going to use that method, please make sure that you at least involve an attorney to make sure that it's not effective immediately. And that you're walking around healthy, but you've given someone sort of keys to your account. And the other one is if you set up a trust, make sure that they also not only deal with death trustees, but also deal with disability trustees. Yes, sir.
Relative to trust, differentiate for me the trustee and a beneficiary.
A beneficiary is the person who will get your things once you pass away. They receive your assets. A trustee controls your assets for you. They don't have power to do just whatever they want to do, and they should receive some counseling when they're a trustee. And one thing I tell people when they pick their trustees, I ask them questions. Are they good with their own money? Because if they don't pay their own bills, why are you going to give them access to your money? So just be real. I have a lot of clients come in, I want my son. Your son lives in your basement? Now, why is he in your basement again? Well, because he got put out of his house. I don't want him to be your trustee. You can certainly do that, but I'm going to have to give you some tough love. If he's not taking care of his own finances, don't put him over yours. Looking at people's age, I have people who, they put their sister-in-law who, you know, and I love my seniors, I'm not just picking on y'all, but I'm 79, and I put my sister on my account who's 81 to be my trustee. Okay, well, she might be a very vigorous and healthy 81-year-old, and you might last 10 years, and she may be here 10 more years, but, you know, that's why you have counseling. That's why you need legal counseling, so we can ask these questions about who would be a good selection for you.
If you donate your body to science,
Mm-hmm.
the person that you leave your power of attorney to, will they have to take that to wherever it is necessary in order for you to be able to donate your body to science?
The question was, if you donate your body to science, will the person you leave the power of attorney to have to take your body to wherever it needs to go? Here's something that people don't know. Powers of attorney discontinue when you pass away. So people tell me, I say, well, who's going to take care of distributing your stuff when you die? And they say, oh, my sister got my power of attorney. The language in your power of attorney can either say it can be a date that you set certain, or it says, or at your death, whichever is later. So powers of attorney don't do anything about what happens after you pass away. The financial ones don't. The healthcare ones, you usually let them last about a year or 6 months, or you can put a date on there, because they may have to do an autopsy depending on how you passed away. They may have to take care of organ donation. They may have to take care of donating your body to science. They may still need to tell the funeral parlor what to do. If it expired at death, how would they get any of that done? But this is something to keep in mind. Financial powers of attorney die when you die. Healthcare powers of attorney, when you download them offline, they'll die when you die too. You need to talk to an attorney so they can put language in there. And if you know you want to donate your body to science, you can do that. There's also another document which you can get if you talk to an attorney called disposition of remains. I do that when I do trust. And then I say, because you may want one person to talk about what happens when you're alive and you need to go to the doctor, but I've talked to my sister Michelle. And she knows I want to be in that plastination exhibit they had at the Museum of Science and Nature. And she knows I want people to see, you know, me jumping rope, you know, that I never did when I was alive, but I'm doing now that they got me on display. She knows that. And so maybe I'll put her as the person who's over my disposition of remains. But that is a good point that I want to point out, that some of these documents die when you die. So you need to have a checkup, a legal estate planning checkup, and say, what's going on with these documents? Do they terminate when I die? If they do, what do I do after I pass away?
Isn't it also important for some of us to
know that if I'm her sister and she was the power of attorney of a parent, that upon the death of that parent, if she has irresponsibly handled that she can be prosecuted by the other sister.
Absolutely, absolutely. And what can happen is,
What was the question?
oh, I'm sorry, if my sister has power of attorney over my parents, and she's acting irresponsibly. This is anybody with power of attorney, trustee, or anything like that. Can they be prosecuted? They most certainly can. You see people down there, the worst place to go if you want to go get a show is wide open, the probate court. I thought I was going to get shot in probate court. Seriously, I said, okay, I grew up in Roseland. I might have expected something to go sideways there, or in 26th of California, not in the Daly Center, in probate court. But families get emotional about these sorts of things. And I was there, and the gentleman threw a bottle of water at his attorney. And the bailiff went for her gun, because she didn't know what was going on. Because emotions are high. So the more that you put in writing for your family, the less that there is that kind of controversy about what was supposed to be done. And then maybe you won't wind up, your family won't wind up down in probate court with a judge trying to decide. So yes, if ever there's anyone who is having any kind of malfeasance, they're not doing what they're supposed to do, all of you all need to know that too. If you have people with powers of attorney, or people who have trustees over people, and you know they're not doing what they're supposed to be doing, unfortunately you may have to go down to probate court and start a petition to get them removed from their position, because they have a duty that they're supposed to perform. Question?
What is the advantage of putting your property and things in a trust?
The advantage of putting things in a trust as opposed to a will has to go to court. Sheila gave away my little punchline when she put that in the thing, but I'm glad she did that, because a lot of people are most shocked about that. I said, what's going to happen when you pass away? People who have done their, and that's why when Sheila kept saying everybody needs a will, everybody needs a will, I said, well, we need to decide when you talk to an attorney whether a will is better for you than a trust. A will requires your family to go down to the probate court to open up probate. What happens when you have a will is the first thing they need to do is they go file the will. That part is free. They go put a copy down at the Daly Center. The next thing that needs to happen is they need to open probate, which is called beginning a court process. Because what has to happen is a judge has to look at this will and say, okay, in Illinois we require 2 witnesses, we require this to be notarized, we require it to be dated, we have a few other requirements, let's see if this will is actually valid. It's not about who left what. I don't care if you left Junebug everything and you didn't leave Susie Q nothing. That's not what the judge is looking at. The judge is saying, in substance, did you do what we are required to do in Illinois for a will? If you name someone an executor, people contact me all the time and say, I'm an executor. I say, have you gone to court yet? They say, no. I said, well, you're not an executor yet. You've been named an executor, but a judge has to approve that. A judge first has to say if the will is even valid. And then if you've been named the executor, you may be, but it may be the case is what this story said, you've already been doing some shady business, and you've been named executor. And I come to court and I tell the judge, well, before my sister even filed this will, she gave all her kids the money that was in the account. The judge is going to go, well, maybe she shouldn't be the executor. I know that's what this will says, but now she's not going to be the executor. Who else wants to be the executor? Who else can I look for in the family? The major issue with going to probate court is just like going to any other court. First, it costs money. If you're leaving things to your children, and you already know, and they're in a precarious financial position, right now I think it's like $395 to open probate. That might not be a lot of money, but depending on when you pass away and who's responsible for this, they may not have $395. So a lot of times they can't even open probate. Probate, they do not let people go pro se. It's too complicated. It's too much going through those probate laws. So if you've been named an executor of somebody's will, you're going to need to hire an attorney, because they're going to need to walk you through what you're supposed to do to make sure you're not running afoul of the law. If you have a trust is a contract. I can make a contract with anybody to do whatever I want to do. So basically a trust is a contract between me and the people I pick as trustees, and I'm giving them instructions on what I want them to do. No court involvement. Once I pass away, the trustees already know, or a lawyer notifies them, and they can begin to immediately and follow my instructions.
Okay, which is better, say if you have everything you have, put it in a trust fund, like your house, your bank account, in a trust fund that is, a bank would do that, you would have it at a bank, or somebody would do that. Which is best, to have a will so that you go to probate?
It's an individual thing.
What's the advantage?
that was the advantage of having a trust, is that you do not have to go to court. That's the first advantage. They don't have to pay to open up an estate. They can start distributing things right away. They can start taking care of things right away. If you have a will, they have to go to court. They have to open probate. They have to have an attorney. And the second thing about probate is most probate cases have to be open a minimum of 6 months. That is what the statute requires. So they open probate. You may not be in court every month. You know, they just open it. Then you go, and if you're supposed to divvy things out, you divvy things out. You make a report, and then 6 months later you come to court. But probate is not closed until after that 6 months. So that is another thing that's also an expense that they will have, because they'll have to have an attorney to open and close probate.
So Sora, why would you do a will? It doesn't sound like there's any advantage to doing a will.
Some people just prefer wills. I mean, wills are simpler. I mean, people do a lot of things that, you know, and sometimes you have to talk about your individual circumstance. A will is less expensive. A will is less expensive on the front end because they know you're going to have to pay an attorney and you're going to have to pay the court on the back end. So usually a will is less expensive. And so if maybe you're leaving stuff to your children and they got a bunch of money. I'm not going to pay for a trust where they could just pay to go to probate. I mean, let's be honest. If they have the means to do it, then maybe you want them to do that. And so maybe you just want to, like a lot of my seniors who are in nursing homes and things like that, they will do a will because it's less expensive for them and they know that their children have the means to take care of opening probate.
Did you say what the average cost of a trust is?
It depends on who you go to. And it also depends, there's another thing that I want to talk about briefly too, because I know Sheila gave me the hand and this is a lot. If you're concerned about Medicare, if you're concerned about public assistance, if you're leaving things to people, if people are on SSI, if they have Link, if they have Section 8, if they have any of those things, they are not supposed to get lump sums of money because their services will be discontinued. And so if you know of people, if you know you're leaving something to a person who has public assistance, you definitely need to have a trust because you need to set it up so that the funds don't go directly to them. They go to a trust for them. Because if you're only leaving them $2,000, they're still probably going to need their Section 8. They're still going to need their Link. And you don't want to give them $2,000. They get it in their bank account and now all of a sudden they're ineligible for all of the public assistance they receive. So you had your hand up for a long time.
No, I was going to ask you to touch on those of us who have insurance policies leaving our beneficiaries who are minors
Absolutely.
lump sums of money and how they should handle that, and is that advisable?
Thank you. And I know I have, and again, I apologize, Soars, in advance. This is usually like a 2-hour seminar. We're just trying to give you a tidbit. I have cards here. There's plenty of Soars here, attorneys, so I expect that you're going to need to follow up. But that's a good place to leave it. A lot of people